House Bill 2007 relating to disclosure of wage information.
Recognize Senator Rosenbaum.
Thank you, Madam President. Colleagues, I bring you House Bill 2007A, which comes to you from the Senate Committee on Workforce. This bill addresses an extremely important problem that we have in Oregon that has persisted for a long time. Basically, it's the lack of equal pay between women workers in Oregon and men workers in Oregon. This bill will take a small but important step to giving women and other workers the tools to address the equal pay problem and lack thereof. I think you know, and it has been well publicized, that right now women in Oregon earn approximately 79 cents for every dollar that men earn in comparable work, and that is despite the equal pay laws and sex discrimination laws we already have on the books. And for minority women, that gap is even greater. And this led our Labor Commissioner, Brad Avakian, to direct the Oregon Council on Civil Rights in 2011 to create a formal set of policy recommendations regarding equal pay in Oregon. Then 2 years later, in 2013, we passed Senate Bill 744, directing the Council to study wage inequality and the factors that contribute to it. So they came out with those recommendations a year later in January, and this bill is one of the recommendations that was contained. House Bill 2007 would address one of those recommendations, whereby current law prohibits an employer from discriminating on the basis of sex in compensation or any other terms or conditions, but doesn't address employer policies that prohibit discussion of wages. And this bill would simply correct that by making it an unlawful employment practice to discharge, demote, discipline, or retaliate against an employee who's inquired about, discussed, or disclosed their own wages or those of another employee or made a complaint acting on that information. So House Bill 2007 would remove the threat of discipline so that women or other workers can learn how much they are being paid in relation to other people in the same workplace, and therefore be in a better position to negotiate for equal pay for equal work. Now, some people would say that we don't need these laws. All we need are people to be more assertive about asking for what they think that they're worth. And although I certainly support assertiveness training and standing up for yourself and asking for a raise when you think that you're underpaid, it's pretty hard to do that if you're prohibited or could be fired from asking the person sitting next to you how much they're getting paid or making a request for a raise based on finding out that information. And that, too, is what this bill is meant to address. I also think that doing something about this wage gap is good for everybody, employers as well as the employees who are suffering from it. There's an organization called the Society for Human Resource Management, or SHRM, which is an employer-funded human resource consulting organization, and they have come out with a study that shows that businesses that have wage transparency policies, like the one this bill would call for, experience improved staff retention, increased workplace efficiency and work productivity, greater trust between employers and employees, and swifter resolutions of claims because they were easier to investigate. Now, we know that 2/3 of women in Oregon are the primary or co-breadwinners in their family, and having the fact that they take home less income and are less likely to earn wages and raises and promotions is hurting the whole family and ultimately the whole state of Oregon, because it isn't just the monthly pay slip where you're suffering this. If you have a retirement plan in place, a wage gap like this one will cause you to lose literally thousands or hundreds of thousands of dollars in your retirement over a lifetime of these inequities. In closing, I just want to mention again an example of how secrecy can hurt people in these situations. I think many of you are familiar with the story of Lilly Ledbetter. She's become kind of the national poster child for equal pay legislation. Lilly Ledbetter was a woman who worked at the Goodyear Tire Company, went to work, worked her way up from the assembly line, became a supervisor, worked there for over 20 years under a policy that said she was prohibited from discussing her wages or finding out what anybody else was being paid. She gradually began to realize that she was getting more and more responsibility as she worked her way up, became a supervisor, saw other male counterparts doing, sometimes not working the hours she was working or with the responsibility, but she never really knew how much they were being paid versus how much she was being paid. Finally, after this had gone on for about 20 years, somebody slipped her a note saying what she was being paid in proportion to her male counterparts, and it turned out she was earning about half of what they were, and that had been going on for a very long time. Unfortunately for Lilly Ledbetter, when she tried to file a discrimination complaint on the wages that she had been losing, that complaint was time barred because she hadn't filed it way back 20 years before when she started being paid less when she was first hired, and appeals of that went all the way to the U.S. Supreme Court, and ultimately she lost out. And that is not something that we want to have happen to women in Oregon or any workers in Oregon. So this bill will simply provide the protection that you can find out how much you're being paid in proportion to coworkers, and you can't be fired or disciplined because of acquiring that information. I think it's time for Oregon to live up to our historical leadership on issues of fairness and equal rights by passing this bill. And colleagues, I urge your aye vote. Thank you.
Discussion. Recognize Senator Thatcher.
Thank you. To the bill.
To the bill.
I think most employers believe in open conversations and believe that these conversations are already protected in law under 659A. But there are concerns that are brought up that are valid. However, what is being done in this bill does not address wage inequality. It does, however, tee up employers for yet another lawsuit. Concerns about discussion of wages of another employee. There are third parties here that might have their wages discussed, and they didn't maybe want to have their own wages discussed, but they are an aggrieved party. This goes beyond discussions among employee to employee discussions. It's much broader. It's a discussion of wages in any manner, and that sets an awfully low bar, and I think it puts a chill on these discussions in the workplace and creates problems for employers, and I would urge a no vote.
Recognize Senator Johnson.
Thank you. Colleagues, I rise as a woman incensed by the gender gap problem in the workplace. This bill, however, is an overly simplified fix to that inequality. It gives rise to the potential of significant unintended consequences, including large-scale litigation. Remember, it creates an unlawful employment practice against an employer who takes any negative action against an employee for disclosing in any manner his or her wages or those of another employee. Colleagues, I'll bet we all stood before a podium sometime during our campaigns and promised to help small business. This bill hurts business, and I urge a no vote.
Recognize Senator Edwards.
Thank you, Madam President. A question of the carrier.
Will the carrier yield?
Yes, I will.
Thank you. I think I know the answer to this, but I just wanted to clarify because in your remarks, you had referenced a study by the Society for Human Resource Management, and then you said you referenced wage transparency policies, which this bill would require. And so could you clarify what you mean by wage transparency policy, and does this bill require that an employer make other employees or their employees' wages transparent from among the workforce, or does it not?
Thank you for that question, Senator. certainly the bill does not require an employer to have policies that would require employees to disclose their wages if they choose not to do so. I think what the SHRM report addressed was having policies where somebody can't be disciplined or fired because they choose to reveal their wages or find out what a coworker's wages are, and then file a complaint based on that. That kind of policy was the kind of policy they were talking about. Certainly, I don't think anybody has ever suggested, and this bill does not do anything to require people who want to keep their wages private from doing so. And in fact, the bill has an exception in it that if people who get that information as part of their job were to disclose it, they are not subject to being protected under this bill at all. They could be fired because that would be violating somebody's confidentiality.
That's it. Thank you.
Further discussion? Recognize Senator Olson.
Thank you, Madam President. Will the carrier entertain a question?
Will the carrier yield to question?
Yes, I will.
Thank you very much. As an employer myself, the concern I would have is, say a person comes in, and this is a hypothetical, of course, but a person comes in and says that, Alan, John is over there, he's running the jackhammer, and he gets $28 an hour, and I'm holding the hose, and I get $24 an hour. So I think I should get paid as much because he runs the jackhammer. And I say, well, your jobs are not comparable. And hypothetically, if this complaint goes on and on and on and becomes annoyance to me as an employer in difficult work conditions, and I decide to terminate that person because of the fact of their continuous requests for a raise to do a job that is not similar, would I be held liable under this as an unlawful employment practice?
Clarification, Madam President.
Would you please clarify your question?
Are you asking if you would be held liable if you fired this person for bringing up this wage disparity repeatedly?
Continually.
Yeah.
And causing a disruption in my workforce.
It's hard to answer hypotheticals, but I think in general, if these two employees were, if it was a female employee approaching you saying a male employee was being paid $4 more an hour to do the same work, she would be able to have protection right now under the equal pay statutes by filing a complaint with the Bureau of Labor and Industries. So I would advise you, and I'm not an employment lawyer, but not to fire people even now for asking or questioning their pay, but for other things that have to do with the workplace, which you as an employer control. So if the employee is disruptive in ways that you find unacceptable, that would certainly be, and I'm assuming it's probably an at-will situation. You don't have to give any reason for firing people right now, but certainly not a good idea to fire people under the current law, even without this bill, for questioning whether they're being paid a fair wage for what other people are being paid in your workplace.
Thank you very much for the answer. To the bill, Madam President?
To the bill.
Colleagues, as an employer, as many of us are, work relationships are at times tenuous. At times people think that I abuse my employees because I make them carry too much weight, or I make them climb a ladder or do different jobs. The situation is that we should always pay people that do equal work the equal amount of money. There's no question about that. The point is, though, that sometimes people perceive that they are doing a job that is equivalent to their neighbor, and that person might be a female and the neighbor might be a female or might be a male. And their perception indicates that I should be getting more money because I work harder than they do. I produce more than they do. And so they go to their boss and they ask the question, hey, I need to have more money because I think she makes more money. I talked to her, and she makes $1 more an hour than I do. Oh, she's been here for 20 years. I've only been here for 8 months, but I'm doing what I perceive to be equivalent work. And colleagues, this puts a real burden on the employer because of the fact that it's difficult to say to the person, no, you don't quite do the same thing, or they've been here for 20 years and they should earn more than them. So it really causes a problem for the employer. So the employer gets put by this bill into a damned if you do and damned if you don't position. You're damned if you do increase this person's wage to accommodate what this lady makes, but then this lady gets concerned because she's been there for 20 years, and she should be making more than this lady because she has much more experience. So how does this bill include an experience level predicating pay? I mean, this to me is what we say is a unionization of the payroll. All union members get the same amount of time or same amount of money. But in the world that I live in, experience counts. And experience counts as you work your way up the scale to make more money than the person that comes in and allegedly does what you do. So, colleagues, this bill really is a detriment to employers. Most employers are wise enough to make certain that their people are paid correctly and appropriately. But when you get into a situation where we talk about, I need to make as much as they do, and I've chatted around, and you cause a hostile work condition in the building, what is the employer to do? Is the employer to just arbitrarily say, you're going to get more money because you've caused a ruckus? Because certainly from this bill, you can't fire them. And if you do, it's a huge lawsuit. Another one of these lovely little lawyer tools that we have. So colleagues, put yourself in the seat of the employer. Employers love their workforce, at least most do, because they know the workforce is what generates the income for the business. This bill puts the employer in a very, very difficult situation. Also, this bill, when we have companies that look at Oregon and they say, I'd like to move there, this is another one of those little tricky little things that end up in rules that employers look at and say, it's too difficult to do business there. It's just too difficult. Should we pay people that put together ballpoint pens on an assembly line the exact same amount? Of course we should. Women should not be discriminated against. Should we honor and benefit those people that have been loyal employees for years and years and years doing the same job? Should we not honor their loyalty to the company and the work that they do? Of course we should. They should get bonuses. They should get extra pay. This bill is a can of worms waiting to be opened, and I will not support it. Thank you.
Recognize Senator Steiner Hayward.
Thank you, Madam President. To the bill.
To the bill.
Colleagues, I appreciate the concerns raised by those who oppose this bill, and I understand the challenges facing employers. Most physicians are small business people as well. That being said, I would like to make a couple of comments in support of this bill that I think address some of the concerns. First and foremost, all good employers, and I would hope those who have spoken from the position of employers have the same practices, do a really good job of documenting why they pay people what they pay them. They document the person's experience. They document their responsibilities. They document their time with the company. They keep things clear in personnel records about why certain people are being paid what they're being paid. On the same side, if they're having concerns about an employee, and I've been a medical director of a large private practice, and we did this with our professionals, with the physicians we were having problems with, or nurse practitioners. We documented explicitly what those concerns were. We made it very clear. We had very clear conversations, and we documented those conversations, whether it was about pay and compensation structure, or concerns about patient care, or any other reason. We documented very clearly what our concerns were, so that when it came time, and I had to do this once, that I had to terminate the employment of a physician, the paper trail was crystal clear, and there was absolutely no question that we had a strong case for terminating this person's employment. And I would hope that in the situations that have been raised by those in opposition, that they would do equally good jobs, and other employers would do equally good jobs of following best practices in human resources whether an employer of 3 people or an employer of 300 or 3,000, to document clearly both the positives that give employees increased pay and the concerns that might lead to justified termination. Furthermore, women have historically been taught that it's unseemly or unladylike to talk about money. And this is held over for many of us in the workplace. Women are anxious about talking about money, and it makes them much less likely than men to talk to their colleagues. And when women do ask for raises or talk to their colleagues, they're much more likely to be disciplined or turned down. The more transparency we can have in the workplace about justifiable or unjustifiable differences in compensation, the more likely we are to have a robust economy, to not have women more likely to live in poverty, or our children living in poverty when women are the primary breadwinners in families. Colleagues, this bill is very simple. It is not the complicated thing that people are making it out to be. It's simply saying that if the only cause for termination is discussing compensation with another employee, that is illegal. That's an unfair labor practice. It's nothing more and nothing less. If employers follow good practices, this will never become a significant issue, and I urge your aye vote. Thank you, Madam President.
Recognize Senator Thompson.
Thank you, Madam President. To the bill.
To the bill.
I just want to make a quick little point. The point I want to make is small businesses. I have an orchard in Hood River. I am the human resource department, do the bills, do the payroll, and it's another layer of paperwork that we're going to have to keep on all our employees so that we can prove things when they come to us with when legal services shows up at our door and wants to file a complaint, and it's just paperwork after paperwork. And most of you do realize, but you need to be reminded that most small businesses are the owner or is the whole ball of wax. We are we do the payroll, we pay the bills, we're the human relations department. We are not big departments where you have 500 employees and you have 3 or 4 people working in those human resources departments, and they keep track and do all the regulations and do the paperwork and keep you in order. It's too easy for things to slip through the cracks when we're busy working and doing our daily chores to keep up with more and more regulations on small business, and that's what this does. I'll be a no. Thanks.
Recognize Senator Dembro.
Thanks, Madam President. Colleagues, we had extensive discussion of this. We heard a lot of testimony in the committee from people on all sides of this issue, and certainly there was concern about litigation that would flow from this and the lawsuits that would increase and the burden on small businesses. But, opponents were unable to show any evidence that this has led to an increase of litigation in those states that have policies like this. And, I would say that, in anticipation, I can see a lot of concern and fear. But I think in fact, those fears really are overblown. And, if I can just address the scenario from our good friend from the heart of Clackamas County, if the employee came and complained about her salary and he fired her as a result of that, I think he and I would agree that that's not something that should happen. If that employee were to continue to raise the issue to the point that it really became a nuisance and a disruption, then that employer would be free to tell that employee, I've already told you, stop bringing this up again. This is disruptive, and I really can't entertain this anymore. If the employer were then to fire that employee, I can pretty much guarantee you that suit would not prevail, that the employer would have been terminating that person not for asking about their salary, but because of their repeated misconduct, especially after a warning. That really does not seem to be too much to ask here. And as you've heard, there are many good reasons for this policy, and that's why I would urge an aye vote.
Recognize Senator Winters.
To the bill.
To the bill.
I had not planned to speak to the bill, and certainly I think all of us would agree we believe in equal pay for equal work. But having heard some of the discussion, and I too believe this has a very adverse impact on small businesses. As a owner of small businesses, of Jackie's Ribs, the time that it takes to do the amount of paperwork that's already there. And most small business owners are not only the ones that have probably a small number of employees, but they're the hands-on. They're right there side by side doing the same thing that their employees are doing. It's not as though you're this lofty supervisor that have a cadre of attorneys and a cadre of accountants and all of these. That's not the real world where small businesses owners live. And and it is opening up for litigation, because all it takes is just a little bit that's skewed to talk about lawsuits. And so for those reasons, and on the record, I do believe that we need to address the equal pay for equal work and that disparity. And maybe, colleagues, we need to start right here with our public institution here at the Capitol. For that reason, I'm going to no vote.
Recognize Senator Girard.
Thank you, Madam President. Colleagues, the question has come up, and the good senator from Salem gave testimony about how it is about litigation, and I would just like to chime in that she's absolutely right. If you look at who's supportive of the bill, gee, many Christmas, it's the Oregon Trial Lawyers Association. They haven't been on a bill on which they come out financially yet, so this is going to mean more money for the trial lawyers. Plain and simple. They wouldn't be on it if they didn't make more money. Now the question is, if you keep good records, you're going to be perfectly safe. Believe me, you need to keep good records, but that doesn't prevent someone from taking a claim to BOLI. If you go to BOLI, you have to pay the legal fees that are involved with that. So good records aren't a protection. It helps, but it's not a protection. If they take you to court and the skids are greased with this bill, then who has to pay the attorneys? You have to pay your own attorneys. So it's everything about litigation, and the bill just is simply a bad bill.
Is there anyone else who wishes to speak? If not, Senator Olson, you may speak for a second time.
Thank you, Madam President. To the bill.
To the bill.
Colleagues, when you look at the bill, you look at page 1 and you see section 1 and section 2. But read further. Read further in this bill, because this bill already is in effect, and this just adds a little bit more to it. The good senator from Senate District 9 mentioned the fact that the employer would have to pay the plaintiff's lawyer's fees. The court shall award reasonable attorney's fees to a prevailing plaintiff. It doesn't say to a prevailing defendant, which would be the employer. And the fact is that a small business, whether it has 2 people, 10 people, or 50 people, what are the costs that are incurred by the business when he has to defend a lawsuit, when he has to make certain that his paperwork is correct? Once again, I wholeheartedly believe that if you are doing equal work, you should get equal pay. Of course, it's predicated again on how long you've been there. You come in as a legal aid assistant, you've been there for years, or for 1 year, and your base salary is $30,000, and the other legal assistant has been there for 20 years, and their salary is $44,000. Because you do the same work that she does, should you get the $44,000? I don't think so. Because you knew when you came in it was a contract. This is what you were getting hired at. This is the rate you were getting hired at. But it goes back to keeping records. The good senator from Hood River talked about the fact that as a small business owner, he is everything. I am everything. I'm out there every day with dirt on my hands and mud on my boots. And I don't have time when I come home to fill out forms and say, how did Bob and Jane do together, working together? And I wouldn't have the documentation. But yet I could be charged into this as an unlawful trade practice. And I would have to defend myself. And what would that cost? Lawyers aren't cheap. Certainly would cost me more than it would be worth. So what would be my next option? Just don't hire the person. And that's not what I want to do. That's not what any employer wants to do. But folks, we have to be realistic. This is the real world. This isn't fantasy land. This is a situation where we're telling the employer, you better have the strictest rules and regulations to make certain that everybody knows how everything is played. And if one person figures they're making $1 less, you better have all the documentation to cover that. That's not the real world. Yes, there are cases where women get paid less. There's also many arguments as to why women get paid less. We won't go into those. The fact is that this is a terrible bill which will have unintended consequences for years to come in this state. And I urge your no vote.
Recognized for a second time, Senator Edwards.
Thank you, Madam President, to the bill.
To the bill.
So I wanted to address a couple of the concerns raised by the good senator from the heart of Clackamas County. I do think that, yes, as an employer, you do expose yourself legally if the basis by which you compensate folks is arbitrary. And as a former employer myself in the private sector, I came to realize after I had been in management for a couple of years that there were clearly some employees that were quote, worth more to me, and that I wanted to, that I really wanted to make sure that we kept around and we kept happy. And so I started looking at what are the criteria, because we paid everybody the same. I mean, all the shovel operators, the yard shovel operators made one wage. The in-feed shovel operator made a different wage. The saw operator made a different wage. And then the millwrights, depending upon where they worked in the mill, made different wages. But there was one wage for that particular classification. But I knew intuitively as an employer that certain folks, regardless of gender, seemed to be more valuable to me. And so when I looked at the underlying criteria, I realized, well, it's because some of these folks are cross-trained, and I can call on them to do anything. And I wanted to make sure that the compensation policies in our company reflected that. So, in fact, we changed the compensation policies to include a cross-training program and had that opportunity available to everybody. And yeah, we had to document it. You know, and that's what insulated us, I think, from legal action. We said, okay, well, you know, if your base job is you're the saw operator, but you spend time and you get cross-trained on being the in-feed shovel operator, and that was valuable to us because we did not have just extra bodies just floating around. The profit and loss margins were way too tight in that business to just have extra people. Then, yeah, you're worth more to me as an employer, and we will pay you accordingly. So we had these policies set up. They were the same for everybody. We could document it, and I think that any human resource attorney would tell you, you need to be doing that anyway, so that your employment practices, so that your compensation practices are not arbitrary. And so, you know, on the balance, if I were to write the bill, I wouldn't have written it exactly how it is, but on the balance, I think that that this bill gets at underlying problems of potential or of real wage inequality, and it's a good bill.
Senator Rosenbaum, your close.
Thank you, Madam President. Just briefly, well, colleagues, I think we've had a good, healthy debate on this bill, and I just wanted to address a couple of things that came up in the course of discussion. I do want to just share with you that I went to work, I think, about 40 years ago, or probably more like 45. And I started as a telephone operator. And in those days at the phone company, when there was AT&T One phone company, women started as telephone operators, and men started as linemen and central office technicians, and there was a huge wage gap. And that was addressed over time by lawsuits, class action lawsuits against companies like AT&T, so that as I worked my way up, I actually eventually had the opportunity to get into some of those non-traditional jobs. But colleagues, that was back in the 60s and 70s. This is now 2015. This is the 21st century, and yet we still have this problem. And to those who think that this is a full employment act for lawyers, I wonder if they would have made the same argument when Oregon passed our equal pay statutes that are on the books now, because exactly the same language is in there that prohibits sex discrimination in pay, and we haven't found an explosion of frivolous lawsuits, particularly against small employers, where I tend to think there's less of a problem with pay for the very reason that the good senator who just spoke talked about. So I don't think this bill will change that much, but what it will do is prevent somebody from being fired or retaliated against or disciplined for asking a question of their coworker, how much are you making? Or finding out and then deciding to do something about it. If you don't have those tools, you can't address this persistent wage gap. You know, it's 2015, and we still have to celebrate Equal Pay Day every year. This year it was April 14th, and that means women had to work for 3.5 months this year just to earn on average as much as men earned in 2014. And I think we'd all agree that that is not right and that is not fair. And this bill will take one small step to being able to level that playing field so hardworking Oregonians, most of who we're talking about are women who are supporting themselves and their husbands and their families, have a right to earn what their male counterparts are earning. This bill will not change the world, but it will take a step toward equal pay and fairness. And colleagues, I very strongly urge your aye vote. Thank you, Madam President. Thank you, Madam President.
Question now arises on third reading and final passage of House Bill 2007. Those of the opinion of bills to pass, ones their ayes, their names are called. Those opposed, no. The clerk will call the roll.
Roebelin, Rosenbaum, Shields, Steiner Hayward, Thatcher, Thompson, Whitsitt, Winters, Barrett Sugar, Bates, Byer, Boquist, Burdick, Dembro, Devlin, Edwards, Ferrioli, Gelser, Girard, Hansel, Hass, Johnson, Knope, Cruz, Monis Anderson, Monroe, Olson, Prozonsky, Riley, President Courtney. Voting no, Barrett Sugar, Boquist, Ferrioli, Girard, Hansel, Johnson, Knope, Cruz, Olson, Thatcher, Thompson, Whitsitt, Winters, 17 aye votes.
House Bill 2007, have received a constitutional majority, is declared passed.